of James Law Firm with today's Texas and taxes issue. Today, I got a call from a potential client wanting an estate plan and including a transfer on death deed. What is a transfer on death deed? It's a revocable transfer of real property in Texas to a beneficiary that takes effect only upon death. To have a valid transfer on death deed, it must be in the form of a deed, signed like a deed, and recorded. Also, it has to be recorded before the death of the transferor or grantor. Now, I don't know why that requirement is there, but I cannot wait to hear about the case where a transferor signs the revocable transfer on death deed and it's notarized, it's sent for recording, maybe by hand delivery, maybe by mail. And before it's recorded, the grantor or transferor under that deed dies. So the issue will be, was the deed recorded before the death? Do we have to get down to the exact hours and minutes? How will one know the time of death and the time the transfer was recorded? What an issue that will be. But the requirement is there, and the law will probably be changed when the actual problem happens. So, who is a good candidate to sign a revocable transfer on death deed? I say in my practice, typically a client who has probably only one beneficiary that he would like to receive the property under the deed. You could have two or more, but the more is not the merrier. If you have a transfer on death deed to say seven children, like today's client had seven shares, or maybe it was six shares, then those six or seven people would inherit an undivided interest, and they would have to either partition that property, agree for it to be sold, or maybe even have a partition by lawsuit. So a good candidate would be just one or maybe two beneficiaries. In that call with the potential client, I said that there was too many for me to prepare a transfer on death deed, that I would recommend that you have a will or a living trust plan with an executor or trustee appointed who can sell the property and distribute the proceeds to the heirs. Now, if it's divisible land, then a an executor or trustee can have the property subdivided and distributed, and that potential client can do that while he's alive. Have it surveyed, get multiple legal descriptions, and disperse tract by tract to his beneficiaries. So that's what a revocable transfer on death deed is. It's good for some people, not for all. If you got any questions, go to the email address above or give us a call, phone number above. We'll see you next time. Thank you.